Welcome back to Political Science 201. This is Laura Fleming, and this is our 13th lecture, almost done. Here's just a little review question. How many justices make up a majority on the Supreme Court? Well, we know that there are 9 justices on the Supreme Court, therefore majority would be 5. And we're going to see many important decisions by the Supreme Court have been made based on just a bare majority, that 5-4 majority. And we're going to talk about that today. A little overview of our lecture. We're going to continue to talk about individual rights under the Constitution. We talked about the First Amendment last time, freedom of religion, freedom of speech. Today we're going to talk about the Second Amendment, right to bear arms. We'll also talk about the rights of criminal defendants under the Bill of Rights. So this has to do with the 4th, 5th, and 6th Amendments, limitations on how the federal government can treat criminal defendants. We'll talk about the right to privacy, a right that is not specifically listed in the Bill of Rights. This is something that is actually a creation of the Supreme Court. And then we'll go on and talk about some cases under the 14th Amendment involving the concepts of equal protection and due process. And that will kind of bridge us over into our final lecture next time regarding the issue of civil rights. Talking about the Second Amendment, the text of the Second Amendment reads, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." You have to remember, Second Amendment is part of the legacy of the Anti-Federalists. They were all about the negative freedoms, the government, leave me alone freedom. So what the Second Amendment does is it guarantees freedom from government interference. It guarantees the government will leave us alone in our right to bear arms. Again, the amendment does not give us any rights. It assumes that the people's right to bear arms is pre-existing, part of our birthright as human beings. At the same time, just as we've seen with respect to freedom of religion, freedom of speech, there is kind of a balancing act involved when the government deals with the people's right to bear firearms. In the text of the Second Amendment, there are no conditions on the right to keep and bear arms. It just says the right of the people to keep and bear arms shall not be infringed. The question is, what about that clause at the beginning of the Second Amendment, a well-regulated militia being necessary to the security of a free state? At the time the Second Amendment was written, we didn't have a large federal military. We had local and state militias, and the founders felt that it was important for people to keep and bear arms, for people to be comfortable with firearms, be trained in the use of firearms in order to be able to fight in these local and state militias as required. So if you look at the Second Amendment, a well-regulated militia is a benefit of the right to bear arms. It's a benefit significant enough that the founders mentioned it in the Second Amendment, but it's not necessarily the only benefit of the right to bear arms. If we take kind of a politically neutral example, the right to keep and read books. Here's an imaginary Second Amendment where the right to keep and read books is the right that's being protected. And this is exactly the same grammatical structure. If you look at it, it says a well-educated voter pool being necessary to the security of a free state, the right of the people to keep and read books shall not be infringed. So in this scenario, one of the benefits of the right of people keeping and reading books is that you grow this kind of book culture. and as a result, you have a well-educated voter pool. Voters that keep and read books are generally going to be better informed, and this is a good thing. At the same time, this does not mean that if you choose not to vote, or you can't vote because you're too young, or you're not a citizen, or you're somehow prevented from voting, that you therefore lose your right to keep and read books. No, you have the right to keep and read books. We want a culture that promotes keeping and reading books. And one of the benefits is the voting population will be better educated, but that's not the only benefit. And the right to keep and read books does not depend on people voting. This is important because today, obviously, we don't have local and state militias in the same way that they did at the time of the founding. Nonetheless, it appears that the Second Amendment does, in its original meaning, support the right of the people to keep and bear arms, even if they are not part of a militia. Now, there's been a lot of controversy because obviously guns are dangerous and they can be used to inflict great damage on people. And the question is, okay, to what extent is the government allowed to regulate and control the private ownership of guns? So different states have different levels of gun control. Some states are much tighter on the regulation of guns than others. And the question is, using that balancing test that the Supreme Court uses so often, at what point does regulation of guns, do gun control laws, start to infringe upon the Second Amendment? This is a case out of Washington, D.C. Washington, D.C. had very, very strict gun control laws, basically barring the registration of handguns, prohibiting carrying pistols without a license, and again, very difficult to obtain a license, and requiring all lawful firearms to be kept unloaded and either disassembled or trigger locked at all times. So basically, this made it very, very difficult to carry a gun for personal protection in Washington, D.C. Okay, so if all you can have is a rifle or a shotgun, and even that has to be kept unloaded and disassembled or trigger locked at all times, that's going to make it difficult for you to actually use the gun in any meaningful fashion. So there was a police officer, his name was Dick Heller, and for his job, he was allowed to carry a gun. He was required to carry a gun guarding federal office buildings in D.C., but he was not allowed to have a gun in his home. Heller had lived in southeast D.C. Near a public housing complex for many, many years, and he had seen his neighborhood go downhill. It was kind of a drug haven, and he wanted the ability to protect himself and his family. So what did Dick Heller do? He went to the National Rifle Association, and he said, hey, this seems like something that's right up your alley. Can you use me as a test case? He says, I'm pretty sympathetic. I'm a police officer. I know how to carry a gun responsibly. I just want to be able to protect my home and my family. When I'm at home, you could file a lawsuit on my behalf, and we could challenge these Washington, D.C. regulations with a test case, with a lawsuit. And the National Rifle Association actually turned him down. That seems kind of curious. You would think the NRA would want to take a test case for somebody like Dick Heller. But in fact, there's risks to filing test cases. If you file a test case and you win, especially if you go up to the level of the Court of Appeal or even the Supreme Court and you win, that's a great victory. You actually have case law that's binding on the lower court. So you've actually created good case law for your cause that's going to be binding, that's going to be required to be followed in the lower courts across the region or across the country. But what happens if you lose? Well, you could take a case to the Supreme Court and lose, and all of a sudden you have bad case law. Your case has created bad case law, a negative decision that's now binding on courts across the country. And so at the time, there really wasn't a Supreme Court case on gun control and the Second Amendment, and so everything was being decided on a state-by-state basis. And the NRA said they just didn't feel comfortable bringing a case like that. It was too risky. The risk of making bad case law was too strong. But there was another organization called the Cato Institute. It was kind of a libertarian think tank, and they decided that they would take Dick Heller's case. And not only that, they kind of said, you know what, you're a sympathetic plaintiff. We're going to get a group of plaintiffs even more sympathetic. They aim for a group diverse in terms of gender, race, economic background, and age, with 6 plaintiffs from their mid-20s to their early 60s, 3 men and 3 women, 4 white and 2 black. Shelley Parker was a software designer and former nurse who had been active in trying to rid her neighborhood of drugs. She was a single woman whose life had been threatened on numerous occasions by drug dealers who had sometimes tried to break into her house. Very sympathetic woman. You can see why she would be a good test case. Tom Palmer. He was a gay man. He had been the victim of a hate crime in the past, and he actually saved his life by defending himself with a handgun outside of Washington, D.C. And all he wanted was to be able to carry a firearm to protect himself from potential hate crimes in the future, and so on. So a total of 6 plaintiffs, all very sympathetic. They took the case up to the Supreme Court, and here you see Mr. Dick Heller waving the victory sign. They did win. So the Supreme Court did affirm rights under the Second Amendment. They said that the Washington, D.C. regulation went too far, and that the Second Amendment protects an individual right to possess a firearm for traditionally lawful purposes like self-defense within the home, even if the person did not serve in the militia. So there's the case. It's called the Heller case after Dick Heller. It was published in 2008, so that's about 12 years ago now. Second Amendment protects the right to possess firearms, but it was a close decision. So, you know, the NRA was right to be concerned about this. Okay, it was 5-4. It could have gone the other direction easily. And the majority opinion was written by Justice Scalia, who, as you recall, is an individualist. So you can see the composition of the Supreme Court, very important. A lot of these cases are very close. I think one thing that we should know about the founders is when they talked about the right to bear firearms, they weren't only talking about hunting, shooting sports. They weren't even talking about self-defense only. They were talking about the ability to defend your freedoms. This is from Federalist Essay 29. Hamilton says, the federal government can never be formidable to the liberties of the people while there is a large body of citizens, little if at all inferior to them in discipline and the use of arms, who stand ready to defend their own rights and those of their fellow citizens. So this is kind of a radical idea, the idea that the right to bear arms is a protection not just against bad guys, but against bad government. that this is another protection for our freedoms, that if the government goes too far, oversteps its bounds, becomes oppressive, that we as American citizens will have the ability to defend ourselves from the government. Here is another quote. This is from Federalist Essay 46. This is Madison talking, and he talks about the fact that, you know, in Europe, many European countries don't allow their citizens to have firearms, and Americans are different. Americans have the advantage of being armed because we trust them. We trust Americans with arms because we trust them, and we want them to have the ability to protect their freedoms. Moving right along, let's talk a little bit about the Fourth Amendment. You'll notice that we're going to skip around a little bit. We're not going to cover every aspect of the Bill of Rights because that would be, you know, simply beyond the scope of this course. So we're going to cover some of the more familiar, more important rights from the Bill of Rights, and that includes this Fourth Amendment. Let me read the text of the Fourth Amendment to you, and it's obviously going to be in your accessible Federalist in the Constitution as well. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, this is a mouthful. Fourth Amendment protects against unreasonable searches and seizures. So the government can't search us, search our homes, and cannot arrest us or seize things that belong to us without good reason. Very interesting. This Fourth Amendment is not absolute. It says we're protected against unreasonable searches and seizures, but not against reasonable ones. So how do you know if a government search or seizure is reasonable? That has to do with the warrant. Okay, warrant, the word warrant just means reason. Okay, if you have a warrant to do something, you have a reason to do it. And so a warrant is a protection for our freedom against unreasonable searches and seizures. This is how a warrant works. So a warrant is in writing. A police officer has to write down this warrant, and the police officer has to take it to a judge. Okay, so warrants are not signed off on by the police officer himself or by the chief of police or anybody else. It's kind of like a little mini separation of powers. So the police have to take this written warrant over to a neutral judge, and the judge has to sign off that yes, you have a reason to conduct this search or seizure. If you look at the text of the Fourth Amendment, it says no warrant shall issue but upon probable cause. This means that the police officer has to have some kind of evidence that makes it more probable than not that you were involved in a crime or that some kind of criminal activity is going to be found in your home. Okay, so police officer can't just go off of a hunch or a gut feeling. They can't go off of, you know, a totally anonymous, unverified tip on the phone. Has to have some kind of evidence that will give them probable cause to suspect that a crime has taken place. And the police officer has to support this warrant by oath or affirmation. The officer has to swear the warrant under penalty of perjury. We're going to talk about this. The police are allowed to lie to you. They're allowed to trick you. Okay, if they're interrogating you, they can say, oh, you know, your buddy in the other in the other question room is getting ready to sing like a canary and turn you in, so you better talk first. Okay, that can be a complete lie. It's legal for the police to lie to you, but it is not legal for the police to lie on a warrant. They have to swear the warrant under penalty of perjury. So let's see, the warrant has to be in writing, has to be signed by a judge, it has to be supported by probable cause, it has to be sworn under oath, and finally, the last protection is that the warrant has to be specific. It has to particularly describe the place to be searched and the persons or things to be seized. So you can't get a warrant that allows you to search an entire housing complex whenever you want. Okay, you can't get a warrant that allows you to stop and arrest any gang member with a particular tattoo, right? Basically the warrant has to say, I would like to arrest so-and-so in particular for such and such a crime, or I would like to inspect the house at this particular location, and I expect to find this particular item inside the house. So again, a lot of protections built into this warrant requirement, including the requirement that it be specific and substantial and supported by oath, etc. Okay, you should know that there are exceptions to the warrant requirement, and there's whole classes in law school about the exceptions to the warrant requirement. These are criminal procedure classes, so we're just going to do a real high-level summary here. Number one, if there's an emergency, no warrant is required. So if a police officer is walking his or her beat and they see, somebody snatch a little old lady's purse right in front of them, they don't have to stop, go to the judge, swear out a warrant, and come back. By that time, of course, the perpetrator is going to be long gone. So if there's an emergency, if they're in hot pursuit, if someone's in danger, they don't need to get a warrant. They do need to still have probable cause before they arrest someone or search. Number two, if police have probable cause to search a vehicle, no warrant is required. There are different rules for vehicles, for cars and trucks, than for houses. And the question is, why would this be so? Well, what's the main difference between a car and a house? It's obvious. A car has wheels. A car can move. The house probably isn't going anywhere. So if the police make a traffic stop and they smell the smell of, let's say, marijuana or booze coming out of the car, they have probable cause to search the car even though they don't have a warrant. Okay. Finally, if you consent, no warrant is required. Okay, so if the police come to your dorm room, knock, 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 can we come in, look around? And if you say, sure, officer, and they look around and find contraband, they don't need a warrant. Now, you may think that, oh, you have nothing to hide, so, why not let the police in? Why not talk to them? Good for you. The problem is maybe your roommate has been up to something that you don't know about. Maybe you had a party and somebody left something under the sofa that you don't know about. So in general, it's better to hold on to your privileges, your freedoms guaranteed by the Fourth Amendment, and not unnecessarily waive them. Okay, so you could try saying something very polite like, officer, I know you're just trying to do your job, but I don't consent to searches. Okay, I don't consent to searches. Maybe you can step outside and talk to the police for a few minutes outside, but you should say, I don't consent to searches, obviously in a polite manner, because the police, again, are just doing their job. If you want to learn more about how to deal with the police, I recommend clicking on that link. There's a little video called Flex Your Power, okay, and it talks about tips for dealing with the police, and it goes through a traffic stop where this young man is getting questioned by the police, and you know, right and wrong responses when you're under questioning. So I think that if you're interested, either Google Flex Your Power, how to talk to the police, or click on that link in the PowerPoint slide. You can watch that little video. Let's move on to the Fifth Amendment. Fifth Amendment also contains multiple protections for criminal defendants. So let's take a look at a section of the Fifth Amendment here. It says, no person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. So there are two important clauses right there. One is the right not to be compelled to be a witness against yourself, and the other is right to due process. We'll talk about both of those. First, we talked about legal privilege in a previous lecture. We talked about the fact that certain conversations are confidential. And in this case, we have a legal privilege called the right to remain silent, the privilege against self-incrimination. This is what it means to plead the Fifth. When you plead the Fifth, you're saying, I don't want to answer that question because my answer could potentially incriminate myself. Why would we have this protection? Why don't we want people to be forced to answer questions from the police? Well, there's the problem of the false confession. Okay, so there has to be some limit on the police's ability to interrogate and ask questions. Otherwise, the concern is that the police would wear people down. People would confess just to end this ordeal, and then that's not justice, right? False confession is not justice. So this is an extra protection. You do not have to talk to the police. You can invoke your right to remain silent. I want to say a word as well about this due process clause. Nor be deprived of life, liberty, or property without due process of law. We've seen due process before. We'll talk about that. There's actually two due process clauses. One of them is in the Fifth Amendment right here, the Bill of Rights. Remember, the Bill of Rights is aimed at the national or federal government. The anti-federalists were worried about the national government, the stronger national government. So the Fifth Amendment says the national government has to provide due process. It says no person shall be deprived of life, liberty, or property without due process. So before the national government can take away your freedom by throwing you in jail, your property by imposing fines, or God forbid your life if your criminal activity was very egregious, before the national government can do any of those things, they have to give you something called due process. Due process just means a fair process, a fair procedure. And typically, fair procedure will include, number one, notice. Okay, so you have to get notice of what you supposedly did wrong. You have to have somebody tell you, this is why you're in trouble. We think you did this. Okay, that's notice of what you did wrong. Second thing is you have to have the opportunity to be heard. So due process is made up of notice and the opportunity to be heard. Opportunity to be heard just means you have to be given the chance to tell your side of the story. Okay, so if you're hauled into court, you're under threat of being deprived of life, liberty, or property. You have to be given notice of the charges against you, and you have to be given the opportunity to tell your side of the story. Where have we seen due process before? Well, you may remember there's a 14th Amendment due process clause as well. After the Civil War, the national government was concerned that states would fail to provide African Americans with a fair legal process. So we have the 14th Amendment that says states must provide equal protection and due process. They have to protect their citizens equally, and they have to give them this fair process. So we have 5th Amendment due process aimed at the national government, and we have 14th Amendment due process aimed at the state government, saying that the state governments have to provide due process. So we're going to come back to this idea of due process. Let's move on to the 6th Amendment. 6th Amendment also contains protections for criminal defendants. The relevant portion of the 6th Amendment says that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. So this is the right to an attorney. Notice that the Constitution does not mention who pays for the attorney. So under the original meaning of the Constitution, there was no question that if you wanted to bring an attorney, you would have to pay for that attorney, right? Remember, the Bill of Rights is a charter of negative freedom. Government leave me alone. And so government leaves you alone. You can bring your attorney to court, but you have to be the one to pay for it. Now, over time, the Supreme Court has interpreted the 6th Amendment in more of a direction of positive freedom. The 6th Amendment as requiring the government to provide a lawyer at no cost if the defendant cannot afford to pay. So in many cases, criminal defendants cannot afford their own attorney. Criminal procedure, the court system does get very complicated, and it is actually helpful to have some kind of public defender, someone representing the accused person in court, just because court proceedings are so complex. So this was a very interesting development where the Bill of Rights was reinterpreted from a negative freedom, government leaving you alone in your right to have an attorney, and now becoming a positive freedom. The government will actually provide you with an attorney if you cannot afford it. And these developments and more were part of a period of time called the Warren Court, where we had Chief Justice Earl Warren. We'll talk about him. Chief Justice Earl Warren, very interesting guy, served during a period of great societal change from 1953 to 1969. What's interesting is that Warren was a former prosecutor, a former district attorney, but he did have kind of a soft spot for criminal defendants, and he reinterpreted the Constitution to include more protections for criminal defendants. Now's a good time to talk about differences in judicial philosophy. So on the one hand, you have judges who believe in judicial activism, and these tend to be the more liberal judges. So these judges believe that their role is to move society forward in a progressive manner. If they feel that justice would be served in a particular decision and reinterpreting the Constitution, they're activists, and they're willing to do that. Okay, they're willing to take action to further their own view of public policy. Usually it's going to be a very liberal or progressive view. On the other hand, you have judges who believe in something called judicial restraint. So this would be originalists like Justice Scalia and some of the more conservative justices. So the idea is that the Supreme Court is supposed to be a check and balance on government power, and the Supreme Court itself is also a branch of government, so it should respect its own limits. So judicial restraint would mean that the Supreme Court is not supposed to be at the forefront of public policy decisions. It's not supposed to be on the cutting edge of change. The Supreme Court is supposed to strike down laws that are unconstitutional according to the Constitution as it was originally written to be a restraint on government. Okay, so those who advocate for judicial restraint, they do have somewhat of a disadvantage over the judicial activists because they actually believe in trying to restrain the Supreme Court itself. So this is kind of an interesting spectrum here, and judges can fall, you don't have to be an extreme activist or an extreme proponent of judicial restraint. You can fall somewhere in the middle. Chief Justice Earl Warren, he was an activist. He believed in reinterpreting the Constitution for modern times. And here's an example. Okay, this is an example of a woman named Dolly Mapp. Dolly Mapp versus Ohio. This case came up in 1961. Dolly Mapp was the divorced ex-wife of boxer Jimmy Bivens, ex-girlfriend of light heavyweight champion Archie Moore, and an employee in the illegal gambling rackets dominated by Cleveland Rackets kingpin Sean Burns. Okay, basically, she was heavily involved in the underground boxing mafia. In May 1957, police officers in Cleveland, Ohio, received an anonymous tip by phone that Virgil Ogletree, who was wanted for questioning in the bombing of rival number tiers racketeer and future boxing promoter Don King's home 3 days earlier, might be found at Mapp's house, as well as illegal paraphernalia. So basically, there's this bad dude, Virgil Ogletree, suspected to have been involved in bombing the house of a rival in the illegal gambling racket. Okay, he was supposed to be hiding out at Dolly Mapp's house, according to this anonymous tip. So the Cleveland police, 3 officers, went to Dolly Mapp's home. Knock, knock, knock. Can we come in? Dolly, who had been around the block, kind of savvy woman, said, "Hang on just a second," and went and called her attorney. And her lawyer said, "You don't consent to searches." So Dolly went back out and she told the police, "I don't consent to searches, and unless you have a warrant, you can't come in." So they left. 3 hours later, several squad cars full of police arrived. They stormed her house. Brandishing a piece of paper, they broke in the door. Mapp asked to see this so-called warrant. Took it from an officer. There was kind of a tussle, like something out of a cartoon. She put it down her dress. They got it back. And this alleged warrant was never seen again. Meanwhile, Virgil Ogletree was found in Mapp's house, as well as some illegal contraband, and she went to jail. Now, Mapp's lawyer argued that the police did not have the right to search her home because they did not have a valid warrant. Okay, they had some bogus piece of paper. But there was a problem. Problem is that the Fourth Amendment protection against unreasonable searches and seizures, the Fourth Amendment requirement to get a warrant, this applies to the federal government. Dolly Mapp's house was invaded by the state police, not the feds. So the question was, does the Fourth Amendment apply to state police? And Chief Justice Earl Warren said, yes, they do. He said the Fourth and Fifth Amendment protections apply against state governments as well as the federal government. And he came up with a very interesting way of doing this. Okay, he says, we have 14th Amendment due process that applies to the states. And we have 5th Amendment due process that applies to the feds. And he lined those two due process clauses up, and he kind of constructed a little portal or wormhole between 14th Amendment due process and 5th Amendment due process. And he says, 14th Amendment due process, what does it mean? It means the same thing as it does in the 5th Amendment. Basically, he says the due process clause of the 14th Amendment reaches up through that wormhole or portal and grabs the protections that are in the Bill of Rights, including the protection to get a warrant, and incorporates those into the 14th Amendment against the state. So in other words, what does due process mean? Due process basically means the protections that we have against the federal government in the 4th and 5th Amendment. And if due process means that in the 5th Amendment, then it means the same thing in the 14th Amendment, and therefore the state police also have to get a true warrant. Okay, that's number one. He solved that little puzzle. Number two, so what happens? The police did not have a warrant. They found Virgil Ogletree. They found this contraband. The cat's out of the bag. Now what do? And there's a penalty that Warren applied to police that don't play by these rules. It's called the exclusionary rule. And this is it. Items taken as a result of an unlawful search or seizure may be excluded from evidence. This is called, again, the exclusionary rule. What this means is if the police misbehave and they obtain evidence in a manner that is not in accord with the Constitution, that they can't use that evidence against the perp. So if they get to trial, they won't be able to use the stuff they found in a house that was searched without a warrant. Okay, police officers don't want that, okay? They don't want to have their investigation tainted and not be able to use the evidence that they've developed at trial, and then maybe the accused person goes free after all of their hard work trying to get that person arrested and build the case, etc. So this is a very strong deterrent for the police to play within the rules, to get that warrant, to have probable cause. Otherwise, they run the risk that the evidence they've developed will be excluded at trial and the accused person will go free. Here's another construction of the Warren Court. This is Miranda rights. You may have heard of Miranda rights before. These are named in honor of a case involving Ernesto Miranda. So I'm going to tell you the story of Ernesto Miranda. It's a case that took place in 1966. It started several years earlier. In 1963, Ernesto Miranda was arrested by the Phoenix Police Department based on circumstantial evidence tying him to the kidnapping and rape of an 18-year-old girl. Okay, so Ernesto Miranda, not a good guy. There's evidence that he kidnapped and raped an 18-year-old girl. The police interrogated Miranda and he signed a confession. Okay, so a confession is like the gold standard of police evidence. If the person confesses, then the case is closed. Now, at no time did Miranda say, I want an attorney, and at no time did he say, I'm asserting my right to remain silent. Nonetheless, Miranda's counsel came up with a very creative argument. He said, my client did not know, Miranda did not know that he had the right to remain silent. He did not know that he had the right to an attorney, and the police should have told him about his rights. Up to that time, if you didn't know about your rights, then bad for you, right? The police could take advantage of that. But no, Miranda's attorney made this new argument that the police should have told Miranda about his rights. The case went up to the Supreme Court, and Chief Justice Earl Warren liked that argument. He said, you know what? Not only do criminals have the right to remain silent and the right to an attorney, they also have the right to be informed and told about these rights. That was the decision. Police have a duty to inform suspects in custody of their right to remain silent and their right to remain counsel. Otherwise, what happens? Otherwise, the confession gets thrown out. Exclusionary rule. Okay, so if you don't tell the person their rights and they confess, the confession gets thrown out. So that's a really bad result, right? The case went back down to the trial court. Trial court tried again. This time they weren't able to use a confession, but they did call witnesses, including Miranda's wife. Miranda's wife was pretty ticked off at him. She could have claimed her own marital privilege, her own right not to testify against her husband, but she waived that. She testified against him, and he actually went to jail. He was sentenced to serve 20 to 30 years, but he was paroled after only about 5 years. He went back to his old neighborhood, and he made a modest living autographing Miranda cards for the police. Okay, so the police had these little cue cards, like the one on the slide. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, you have the right to have one appointed for you, etc. So the police would have these cue cards, and they would have Ernesto Miranda sign the cue cards as a souvenir or memento and give him a couple bucks for it. And so he kind of eked a living out that way. But what goes around comes around. Miranda was in a bar fight. He was stabbed to death. A suspect was arrested, but unlike Miranda, the suspect exercised his right to remain silent. There was no other evidence. He was released. Okay, so very interesting story. So the upshot of all this is that, we have very generous protections for criminal defendants in the United States. Under the Miranda case, police have a duty to inform suspects in custody of their rights. Otherwise, the exclusionary rule applies. And this means that in the United States, we are willing to let bad people go. There were plenty of bad people who were let go as a result of the Miranda case. But we viewed this, at least Chief Justice Earl Warren and the Supreme Court viewed this as necessary to protect the rights of criminal defendants. All right, right to privacy. The Warren Court also created a right to privacy, which it used to push social change. Okay, this is an interesting story. This is Griswold versus Connecticut. Okay, so these two ladies here, Mrs. Janke and Mrs. Griswold, flashing the victory sign, they worked for Planned Parenthood of Connecticut. And their case actually did not have anything to do with abortion. Ms. Griswold and Ms. Janke actually were counseling married couples about the use of birth control. All right, so there was an old law on the books in Connecticut that prohibited the use of birth control. Planned Parenthood of Connecticut violated that law by counseling married couples about birth control, and that case went to the Supreme Court. And we'll talk about this. Supreme Court decided that the Bill of Rights contains an implied right to privacy, which covers birth control for married couples. Okay, so I think it's very easy to be guilty of, remember we talked about presentism, judging previous societies, previous communities based on our present values and morals. Okay, so today we think, who could have a problem with birth control, right? What are they? Some kind of cave people. So the question is, why would the people of Connecticut in the 1800s have a law against birth control? Well, we talked about the importance of the natural family, the traditional family, as a building block of society. Okay, we talked about the fact that, father, mother, biological children, to this day, is the best model for predicting success of a child. Okay, so a child's best bet at having a flourishing and successful life is to be raised by both biological parents married to each other. Okay, this is not always possible. Okay, many cases this scenario is not possible for a variety of reasons, but if you look at the statistics, you'll see statistically kids do better when raised by their two married biological parents. Now, birth control, and again, this has been proven by research, birth control undermines the formation of traditional or natural families. Well, how does it do that? First of all, it makes it easier to engage in sexual activity outside the marriage, right? So if you separate the recreational aspect of sex from the procreational aspect of sex, okay, if you separate out having fun and making babies, okay, that's what birth control does. It allows you to have sex without making babies. If you separate that out, it's easier to commit adultery. You're not worried about getting someone else pregnant or getting pregnant out of wedlock. It's easier to have sex without getting married. If you're having sex, you don't have unexpected pregnancies which push you to get married. So since we've had birth control, people have been waiting longer and longer to get married. Back in the 1800s, it's not like nobody had premarital sex. Some people did have premarital sex. In general, they would get pregnant, and many times you would have couples, getting urged to get married and having a baby right away, right? If you have birth control, you're not having babies right away. You're not making families. The push to get married is much lighter, and the ability to have sex outside of marriage has much fewer consequences. Okay, so it was a different attitude back then toward birth control. Birth control was seen as undermining the nature and purpose of the natural family, and Connecticut had outlawed birth control. Now, fast forward to the sexual revolution of the 1960s. Nobody believes that birth control should be outlawed, except maybe, some people on religious grounds, right? But that's definitely the minority. But the problem is Connecticut still has this law on the books. So what do you do? So this is what Chief Justice Earl Warren did. Okay, he looked at this law that outlawed the use of birth control, and he said, that's a really ridiculous law. There's got to be a way to strike that down. How do I do it? What he did is he looked at the Bill of Rights, okay, and does not explicitly protect a general right to privacy. So there's no right to privacy in the Bill of Rights. Nonetheless, he said the various guarantees within the Bill of Rights create penumbras or zones that establish a right to privacy. So Chief Justice Earl Warren, he used this nice legal term, penumbra. He said the First, Third, Fourth, and Ninth Amendments create a new constitutional right, the right to privacy in marital relations. So basically he looked at the Bill of Rights and he kind of crossed his eyes and let them glaze over, and from the haze emerged this penumbra, which included the right to privacy. Many years ago, there was a fad involving these magic eye pictures. I don't know if you've seen magic eye pictures before, but it looks on first glance like they just have some kind of patterned, picture, kind of a, a random geometric pattern. Supposedly, if you look at them long enough and in the right way, you'll see some kind of special picture emerge out of that patterned backdrop. Okay, I've never been able to do it exactly right, but supposedly if you look at these magic eye pictures long enough, you'll be able to see the secret picture that emerges. Okay, so that's what Chief Justice Earl Warren did. He looked at the Bill of Rights and this secret picture, this penumbra, this implied right to privacy emerged, and he was able to do it because people at the time thought it was silly to try to have a law against birth control. All right, there was a dissent. There was actually more than one dissent. And you can ask yourself, why? Why would a Supreme Court judge dissent against striking down a law against birth control, especially birth control for married couples? What harm would that do? So here's the dissent. He says, since 1879, Connecticut has had on its books a law which forbids the use of contraceptives by anyone. I think this is an uncommonly silly law. So the dissent said that law, I agree, is ridiculous. I believe the use of contraceptives in marriage should be left to personal and private choice based on each individual's moral, ethical, religious beliefs, etc. But we are not asked in this case to say whether we think this law is unwise or even asinine. We are asked to hold that it violates the United States Constitution, and that I cannot do. So the dissent basically says judicial restraint. This law is not unconstitutional. It's not unconstitutional for the state of Connecticut to have a law against birth control, even though the law is dumb. He says, with all deference, I can find no general right of privacy in the Bill of Rights in any other part of the Constitution or in any case ever before decided by this court. He said, I've looked at the Constitution. I just don't see it. I don't see the Constitution giving the Supreme Court the right to strike down this law against birth control. So what do we do then? Does that mean Connecticut is stuck with this law forever? And the dissent says no. If, as I should surely hope, the law before us does not reflect the standards of the people of Connecticut, the people of Connecticut can freely exercise their true 9th and 10th Amendment rights to persuade their elected representatives to repeal it. That is the constitutional way to take this law off the books. So the dissent said, look, Supreme Court is not supposed to clean up after state legislatures. The people of the Connecticut were the ones that passed this law against birth control. If the people of Connecticut don't want a law against birth control, then they can repeal it democratically. He says, you know, the Supreme Court should not be messing with the laws of the people of Connecticut, should leave them to pass and revoke or repeal their own laws unless they're clearly constitutional. He said the Constitution does not prevent the states from passing laws against sexual behavior in this way, and therefore we should leave it alone, let the people of Connecticut deal with the mess that they created. Okay, that was the dissent, a classic position of judicial restraint. Here's Chief Justice Earl Warren, a classic example of judicial activism by creating an entire right out of whole cloth that was not in the Constitution before, this right to privacy. It's interesting how the right to privacy rapidly expanded as well. Okay, so one of the concurring opinions said, you know, don't worry. Right to privacy, we're only talking about right to privacy in marital relations. You know, who could argue against right to privacy in marital relations? But that quickly expanded, and we'll talk about this. Right to privacy has come to mean much more than that. Here's a thought question. Of course, we're getting into some controversial areas now. We're getting into the area of abortion. People have very different views about how our country should handle abortion. And so let's put aside what your view on abortion is, whether you think abortion is a great thing or whether you think abortion should be abolished forever. Who do you think should decide abortion policy? Who should make the decision? Should it be Congress? Should it be the Supreme Court? Should it be each state for itself? Who should decide whether abortion should be legal or illegal? Who should decide what kinds of regulations should be governing abortion clinics, if any? And most of the time we think, I'll just go with whoever agrees with me, right? So if the Supreme Court agrees with me, I'll go with that. If Congress agrees with me, I'll go with that. If my state agrees with me, I'll go with that, right? But again, this is another kind of separation of powers issue, trying to figure out whose role is it to decide these things before we know the outcome. And I just remind you, the Supreme Court is the least democratic branch of government with the least checks and balances. Should we be putting these important topics in the hands of the Supreme Court? Something to think about. Okay, let's talk about Roe versus Wade. Less than 10 years after the Griswold case, where the new right to privacy was used to strike down a Connecticut law outlawing the use of birth control by marital couples, we have a decision, Roe versus Wade, 1973. The right to privacy includes a qualified right to terminate your pregnancy. Okay, so this Supreme Court ruling actually trumped state laws in 46 states. So 46 states had laws against abortion, and the Supreme Court said no. It said this right to privacy includes the right to end your pregnancy, to have an abortion. The Supreme Court said the right was qualified because they had this scheme where the woman's rights took precedent in the first trimester, and then by the last trimester of pregnancy, the Supreme Court felt that the state authorities did have more interest in protecting the right of the unborn child. Okay, so the Supreme Court was very activist at the forefront of this public policy decision. So there have been debate going on about abortion and to what extent abortion should be legal or regulated. The Supreme Court took all of that in its own hands and came up with this new rule striking down state law in 46 states. You can click on this link here. It will tell you the story of Norma McCorvey. She is Jane Roe. So she was the test case involved in Roe versus Wade. One of the interesting things that happened with Roe versus Wade is you would think that the American people would say, oh, okay, the Supreme Court decided that abortion should be legal, and so that's the end of it. But in fact, that was not the end of it. Abortion has become ever more polarizing and controversial. In fact, the pro-life is stronger now than it was in 1973 when Roe versus Wade was decided. And in fact, if you click on that link, Norma McCorvey herself, Jane Roe herself, is now a pro-life activist. So very interesting. The Supreme Court was trying to make this decision about abortion, but so far it has not stuck. There was an attempt to overturn Roe versus Wade in 1992, okay, but still before most of you were born. It was Planned Parenthood of Pennsylvania, I believe. So Pennsylvania put some regulations on abortion, did not prohibit abortion, but just said, you have to give informed consent, there has to be a waiting period, and some other regulations. Planned Parenthood was not happy with these regulations, kind of like Dick Heller was not happy about the regulations on gun control in Washington, D.C. The difference is that, we have a Second Amendment protecting the right to bear arms. We don't have a comparative constitutional section protecting the right to abortion. Nonetheless, Planned Parenthood sued, saying that the Pennsylvania laws were too restricted Pro-life activists were excited about this lawsuit because they thought perhaps this is the chance to overturn Roe versus Wade. So there was a risk to Planned Parenthood bringing this case. The risk is that you could actually get bad case law for the pro-choice camp and have Roe versus Wade overturned. Nonetheless, in 1992, Supreme Court upheld Roe versus Wade, and they simply said that states cannot put an undue burden on abortion, at least not prior to viability. So again, the idea is that the closer you are to the baby being able to live outside the mother's body, perhaps the more interest the state has in regulating abortion. Nonetheless, the Supreme Court declined to overturn Roe versus Wade. They said, we're not going to overturn Roe versus Wade. At the time, it had been the law for 20 years, and they said stare decisis. Remember, we talked about the fact stare decisis means we're standing by our prior decisions. We don't want to overturn prior decisions unnecessarily. That would cause too much chaos and confusion. So Roe versus Wade remains the law. Now, what would it mean if Roe versus Wade was overturned? Would that mean that abortion would be illegal? Actually, that's not what it would mean. If Roe versus Wade was overturned, then the decision would revert back down to the state level. So that would mean that if you were in a liberal state that's generally pro-choice, you can have abortion laws in that direction. If you were in a more conservative state that was more pro-life, then you would have laws that restricted abortion. So overturning Roe versus Wade would not by itself outlaw abortion in the United States. It would just place that authority back into the hands of each individual state. This is why you've seen some states kind of passing different laws. So some of the states that are more pro-life have actually passed laws that say if Roe versus Wade is overturned, then we're going to outlaw abortion once there's a heartbeat or once the fetus can experience pain. Then you have other states like New York, and they're saying, we want to have the most liberal abortion laws. We want to make sure abortion is legal all the way up until the actual moment before birth. And in some cases, even if the baby is born alive after a botched abortion, in certain states that baby may have very little protection. Okay, so you can see the states gearing up, and it's possible that we may have another run on someone either trying to overturn Roe versus Wade or someone protesting state regulation of abortion, saying that it's put too heavy of a burden on abortion through regulation. Okay, so very interesting that this controversy has only grown and become more polarizing, even though it's been 45, almost 50 years since that Supreme Court decision. All right, we're going to talk about the case Lawrence versus Texas. Came out in 2003. Lawrence versus Texas extended the right to privacy to protect consensual homosexual activity in the home. So we've seen the right of privacy start with birth control for married couples, extended to abortion, eventually extended to cover homosexual sex. Now, there were laws against homosexual activity in the past. Many of these laws were removed from the books, so gay activists had good success in getting many of these laws removed. Texas still had a law prohibiting homosexual activity. And now you may wonder, why did it take until 2003, the new millennium, for the Supreme Court to extend the right to privacy in this way? Well, the fact of the matter is that you can't, the Supreme Court cannot act unless it has a case. Okay, so remember, courts are inherently reactive. They can't control what walks into their courtroom. They have to wait for a dispute or a controversy. And most police officers have no interest in starting a controversy by trying to police people's sexual activity in the home. Okay, so this is how the Lawrence case came about. There were 3 men. They had a lover's quarrel. One of the men left the house and called in a weapons disturbance at the address. Okay, so the police got a call and they assumed it was some kind of domestic violence incident with weapons involved. They burst through the door. Lo and behold, they got an eyeful. Okay, 2 guys in the act of homosexual activity. I think the police were probably a little stunned, didn't know what to do, so they arrested them. And this actually was a good thing for gay activists, because this means that they finally got their controversy and they could bring their case to court. And they did. They sued on behalf of Mr. Lawrence and his lover. And they said that the right to privacy should be extended to consensual homosexual activity in the home. And by this time, 2003, this was pretty much a non-issue, and it was extended. Now, Justice Scalia, Justice Scalia actually dissented to this decision. And you might think, wow, is Justice Scalia some kind of homophobe? Why would he disagree with extending the right to privacy to cover consensual homosexual activity in the home? This is what he said. He said, let me be clear. I have nothing against homosexuals or any other group promoting their agenda through normal democratic means. Social perceptions of sexual and other morality change over time, and every group has the right to persuade its fellow citizens that its view of such matters is the best. That homosexuals have achieved some success, and that enterprise is attested to by the fact Texas is one of the few remaining states that criminalize private consensual homosexual acts. But persuading one's fellow citizens is one thing, and imposing one's views in the absence of democratic majority will is another. So he says, it's indeed true later generations can see laws once thought necessary and proper, in fact, serve only to oppress. And when that happens, later generations can repeal those laws. So Scalia is saying if Texas doesn't want a law against homosexual conduct, they can repeal that law democratically. But, says Scalia, it's a premise of our system that these judgments are to be made by the people, not imposed by a governing caste that knows best. So Scalia was saying, look, judicial restraint, guys. This is not a constitutional issue. This is an issue of state law and changing morality. And if the morals of the people of Texas has changed, and the people of Texas can repeal that law, but the Supreme Court should not get involved, should not be at the forefront of change. Okay, that was a minority point of view, and the law in Texas was struck down. Okay, I want to talk a little bit about the 14th Amendment. The 14th Amendment guarantees equal protection and due process. If you remember, it was passed in the Reconstruction period because the nation was concerned that the African Americans and former slaves would not be treated equally and fairly by the states. This is the text of the 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law. We talked about the fact that due process just means a fair process or procedure. So before you're deprived of your liberty before you're thrown in prison or before you're forced to pay a fine, before, God forbid, you're executed for a capital crime, you have to have due process. You have to have notice of the charges against you and also the opportunity to tell your side of the story before a neutral judge. In addition, the 14th Amendment says no state shall deny to any person within its jurisdiction the equal protection of the laws. As it's written, the 14th Amendment stands for equality before the law and no special favors. So these ideas, due process and equal protection, they are somewhat squishy, and they're kind of ripe for the Supreme Court to use in an activist manner to change law to be at the cutting edge of public policy. So the Supreme Court has used equal protection and due process to push social change, most recently in the area of same-sex marriage. Okay, so, take a look at how the Supreme Court has been at the cutting edge of this issue. 1996, Congress passed the Defense of Marriage Act, or DOMA. Okay, so this was passed by large veto-proof majorities in Congress and signed by Democrat President Bill Clinton. Okay, so it had a large public support behind this act, and it said federal government would not recognize same-sex marriage. Okay, so gay rights was becoming more of an issue in the law, and same-sex couples were asking for marriage, and the question was, is the federal government going to recognize same-sex marriage? And according to DOMA, they said, no, we will not. But they gave the states the ability to choose for themselves, right? So at the federal level, the national government said, we're not going to recognize same-sex marriage for national purposes, but each state can make that decision for themselves. States can recognize same-sex marriage if they want. So then we had a succession of two cases. The first case was U.S. versus Windsor. And this is actually a tax case, very interesting. It was about federal taxes, and it involved a woman named Edith Windsor. Edith Windsor was the widow and executor of the estate of her late spouse, Thea Spire. Okay, so Ms. Windsor, Ms. Spire were married under same-sex marriage law in New York. So they were validly married under state law. So far, so good. Their marriage was recognized by New York, and then Ms. Spire died. She left her estate to her spouse because their marriage was not recognized by federal law. The federal government imposed taxes, almost $400,000 in taxes. So obviously Ms. Spire was very wealthy. She left her estate to Ms. Windsor, and under federal law, you get a nice exemption if you leave your estate to your spouse. But because they were a same-sex married couple, they were not eligible for this exemption under DOMA and under federal law. Okay, so she felt that that was not fair. She sued, and the Supreme Court actually overturned DOMA. What the Supreme Court said was the federal government must recognize same-sex marriage if the marriage is valid under state law. So again, under Windsor, states could still decide whether or not they wanted to have same-sex marriage, but if the state recognized a marriage, then the federal government had to do that also, including for tax purposes. So Ms. Windsor got out of that large tax bill. That kind of left open the question, what about at the state level? Are states even allowed to have traditional marriage laws anymore? Louisiana had a traditional marriage law stating that marriage must be one man and one woman only. So this was the second half of the case. This was a combination of multiple test cases across the country same-sex couples who have been denied marriage license in different states. And under Obergefell, the Supreme Court held that all traditional marriage laws are unconstitutional under the 14th Amendment, and it overturned traditional marriage in 13 states. Okay, so the Supreme Court, at the cutting edge of change, not only did they overturn law passed by Congress, DOMA, they also overturned state laws against same-sex marriage. And Anthony Kennedy was the swing vote in these cases, and you know, he tended to make his decisions based on emotion. So he had a very emotional conclusion to his decision. He said, "No union is more profound than marriage. It embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than they were before. Some of the petitioners in these cases have demonstrated marriage embodies a love that may endure even past death." He goes on, he says that these same-sex couples respect marriage. They seek to find its fulfillment to themselves. They don't want to be excluded from one of civilization's oldest institutions. They're asking for equal dignity in the eyes of the law, and the Constitution gives them that right. Okay, so that was Justice Kennedy justifying this decision. So he was a judicial activist, and he believed that this was an important enough issue that the Supreme Court should act, even though there's nothing in the Constitution that prevents either Congress or the states from defining marriage for their purposes. Justice Alito, he was one of the dissenters, and he said most Americans understandably will cheer or lament today's decision. So there were many Americans very excited about this decision, about the opportunity for same-sex couples to get married. And you can see even at the White House under President Obama, very excited about the Obergefell decision and lit up in rainbow colors there. Alito says, you know, whether you cheer or lament the decision, all Americans, whatever they're thinking, should worry about what the Supreme Court's claim of power portends. Should the Supreme Court have this kind of power to contradict a supermajority in Congress, contradict the laws of many states, in redefining marriage in a way that had never been done before? In addition, we have this issue of the clash of different rights. Okay, so if this is a matter of equal dignity, equal protection, what does that mean for cases of discrimination? Let's say that you have a baker, and the baker has a religious belief against same-sex marriage because of his religion. The baker believes in traditional marriage. Should the baker be required to bake cakes and to celebrate same-sex marriage, or be branded as someone who discriminates and be subject to fines under anti-discrimination laws? Okay, so we're opening up a whole can of worms, a whole set of conflicting rights. Okay, and we'll see that many of our rights are in tension with each other, especially when it comes to the area of civil rights, which we will discuss next time. Okay, thank you for listening to this lecture with me. I know these ideas are quite controversial. Feel free to email me with any comments. I'm happy to engage in dialogue with you guys, and we will finish up with our last lecture next time.